Hey, Houston and fellow Texans, how you doing? This is attorney Cory Roth. I'm a criminal defense attorney based in Houston, Texas. I represent clients throughout the state of Texas, but I'm primarily focused on Harris County and Houston, Fort Bend, Montgomery County. Today, I want to talk to you about a case that recently was disposed of. We'll call it State of Texas versus TS. In this case, a neighbor called 911 at about 1:30 in the morning to complain about loud noises like a jackhammer or power tools and bright lights in the middle of the night coming from a service station where my client happened to work and live. The police respond to the call, and there's no lights, there's no loud noises. There are a couple people outside, but there's not a disturbance. There's nothing corroborating the anonymous tip from this phone call. The police arrive. There's four Houston Police Department officers. They lift up some barbed wire, walk underneath, approach some people and some vehicles in the parking area of this service station. And then they walk back into what is clearly the backyard, side yard of this service station that was set up to be private. There was an opening in the fence. There was an opening in the gate, but vehicles and other things were positioned there to prevent the public getting inside. So the officers walk back there and they find a 2008 Suburban that's chopped up. I mean, down to the core, right? Completely disassembled, and they separate all the different people and they interview my client, TS. And over the course of about an hour and a half after Mirandizing him, a Miranda warning, right? A Miranda warning are your warnings about your rights. And in Texas, they're actually statutory rights, or given to you by statute, that you have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to have an attorney present for any and all interviews. If you can't afford one will be represented for you. So this officer uses a very deceptive tactic of basically promising my client leniency, promising him that he'll get him he'll get him off. Maybe he can even get him paid to be an informer, that he probably won't be coming to jail if he continues to tell the truth. And so eventually, over the course of this long interrogation in the back of a patrol car, my client confesses to knowing the car was stolen. Now, he didn't know it was stolen when he received it, but he found out earlier that day that it was stolen, that he needed to hurry up, which is why he was working late at night. So the issue is whether the police conducted a search of property, whether that search was with or without a warrant, and whether that search violated my client's Fourth Amendment rights. So for starters, in order to claim that you have the right to have a reasonable expectation of privacy, you have to have a reasonable expectation of privacy. Now, if you're at your home or your apartment, you have a reasonable expectation of privacy that society is prepared to recognize. If you are a guest if you've rented a motel room or a hotel room, you have a reasonable expectation of privacy in that room during the course of your paid stay. If you're an overnight guest at someone's house, you too have a reasonable expectation of privacy, although it might be lessened. And there are so many different variables that a court's going to use to determine whether you have a reasonable expectation of privacy. And having that, if you have a recognized expectation of privacy, that gives you standing. So my client was a employee of this business, and he was allowed to be there. But of course, that's a difficult thing to get proof of. So over the course of my representation, I identified a couple things very quickly. First of all, especially thanks to body cameras, the officers conducted a warrantless search of what's called the curtilage of the property, the area, the land immediately surrounding the building, where one would expect to be private, that others are supposed to keep out from. So for me, that was a no-brainer. It was a search. The state had a couple things they could have argued, such as it wasn't completely closed off. There wasn't a complete fencing around the exterior, but there was a line of barbed wire clearly designed to keep people out. There was a sign that said keep out. There was large sheet metal fence wall designed to keep people out. And there were vehicles and other things placed to prevent the public from seeing inside the gap, the gated gap where there is now a gate. So it's a search without a warrant. It means it's presumptively illegal. It's presumed to be illegal. And which means that the evidence that was found is called fruit of the poisonous tree, meaning that anything that resulted from that search or that detention or that arguably that confession are inadmissible against my client in trial. So in order to prove that my client has standing, because I anticipated that would be the only argument that the prosecutors would have, that is standing, the right to challenge the search, the right to a reasonable expectation of privacy, I had to prove that he had the right to be there at that time. So myself and my investigator, we filed subpoenas. We went and spoke to the owner of the property. We got the lease of the property. That lease, copy of that lease, directed us to the person who actually owned the business. My client was reluctant to disclose his name. And from there, conducted a little bit of investigation, got the owner's phone number, and I called the owner. And of course, the owner didn't want to be involved at all. So he directed me to his son, who's now his business partner, and his son was working with his attorney. And basically, it kind of became a negotiation between myself and the son and myself and the business owner. The business owner, who, by the way, had hired my client, according to my client, and according to a phone call with the business owner. But the business owner didn't want to be involved. He didn't want to go to court. And you can understand why. He didn't want to get caught up in anything. And unfortunately, in some neighborhoods, people just never want to be involved. Even if it's a family member, they don't want to be involved. They don't want to help people. That's a cultural shift that needs to change, because if there was more community support and more help for defendants and defense attorneys, we'd win a lot more cases. So it came down to the wire. We were set for trial just today, actually. And after basically negotiating with the business owner and his son, I was able, although I did subpoena them to appear in trial, I subpoenaed the business owner to appear in trial. I subpoenaed the property owner to appear at trial, so that I could create this chain to show that my client had the authority, the right to be on that property that night and to be working even at that night. So because the business owner did not want to testify, he wrote a sworn affidavit that very specifically and succinctly wrote what the prosecutors needed to know. And that was that my client had the right to be there. That gives him standing. That gives him a reasonable expectation of privacy. And once he has that, it's a no-brainer that the search was illegal. Now, unfortunately, as a criminal defense attorney, I've come to find out that you're only as strong as your clients. You can only accomplish much as your clients will allow you to accomplish. In this case, I wanted to take the case to trial. I wanted to win the motion to suppress and get a directed verdict of not guilty, based on the fact that the stolen vehicle that was chopped up, would not be admitted into evidence because it was illegally searched. It was illegally seized. It was the result of an illegal seizure. And potentially exclude my client's confession, because it was, first of all, my client never clearly and unambiguously waived his Miranda rights, his statutory rights. And second, because the officer used a lot of, I think, illegal tactics to draw out that confession by promising certain leniency to my client. And it's arguable, there's a good argument to be made that is not allowed. That was illegal conduct, which makes the confession inadmissible. Unfortunately, my client has trouble getting to and from court, and he had a lot of convictions. And I was able to negotiate a time served on a misdemeanor. Now, I'm disappointed that I didn't get to hear not guilty, or that my motion to suppress was granted. But ultimately, it's not about me. It's not about the criminal defense attorney. It's not about my ego. It's about my clients. It's about the citizens accused. And if he wants to get this over with after I made a compelling argument to the prosecutor, now this case has been pending for over 2 years, and the only offer was prison time. So going from 2 years prison, or they offered to 2 years prison or 1 year state jail, down to time served, 3 days. He's over with. He's a very happy guy. And he said, Cory, you're a godsend. You're a blessing. Thank you so much for working so hard. So what you're looking for, if you're looking for an attorney, is someone who will pay close attention to the facts. You're looking for someone who does not accept the police officer's account of events as true. And you're looking for an attorney who knows the law, who can identify the issues. There's so many attorneys out there who don't know, their head from a hole in the ground. They don't know when an officer has violated the law. They can't even recognize it, let alone do the research, find the right case laws, and put together a persuasive argument for a prosecutor or the judge or the jury. I feel like I'm able to do all those things, and that's why I got a great result today. It wasn't the result I wanted, but it was a result that my client was very happy with. And that's, ultimately what it's all about. Different client might have said, you know what, forget it. Let's take this shit to trial. But this client didn't, and I respect that, and he's happy, and this period of his life is over with, and he'll be able to move forward and do great things. My name's Cory Roth. You can reach me at 832-819-5290. Shoot me a text, give me a call. My website is www.attorneyroth.com. And my email address is Cory, Cory, @attorneyroth.com. Look forward to hearing from you. Bye.